If a vendor is unsure if a product is TAA compliant, what process should they go through for discovery on that?
Well, I would say there's probably two avenues that I generally recommend to my clients that they explore. The first is vendor certification. If you are unsure, look, I'm not your lawyer, but I'm your friend. Please don't go out like this is not something where you want to get out ahead of yourself on. This is not something that you guess on. So if you're not sure, like state that, say like unsure, or because you don't want to accidentally misrepresent yourself. So I would say in the first place, the first track, if you're not sure, go to the vendor or go to the manufacturer. That actually might require you to wind back through the vendor to the OEM to, through the line there, but ask them for a certification. Generally speaking, and that certification might be kind of your standard FAR clause certification, although I think generally speaking, that's more than you need. At the end of the day, as long as you get a representation for them as far as what the country of origin is, that's going to do pretty well, especially for TAA compliance. TAA looks just at the end product. It doesn't look at content. And so if you can get a country of origin representation regarding where it's from, then that's good. Now, the important thing is that you can rely on that too, even if it turns out that that's incorrect. If you've gone through the process of being deliberate, of asking these questions, getting this information, and it turns out your vendor made a mistake in giving it to you, well, there is case law that actually says it's okay, prime contractor, you relied on this in good faith. You didn't do anything necessarily with intent to defraud the government. So that's a good first step. Now, if you're relying on vendor certifications, though, I caution that you make sure that you refresh those on a semi-regular basis. Whether it's, I think most companies do it annually, and I think that makes sense. But you don't want to fall into the trap of, I get a certification from Josh Inc. 5 years ago, and then little do I realize that 2 years ago you moved your entire manufacturing to China, and I'm continuing to represent this as a U.S. made product.
Yeah.
That can really be dangerous. And so I think there's a good best practice there. In addition to getting the certifications, whatever that looks like, it's some kind of a representation from the vendor or the manufacturer, and then making sure you're refreshing that on a regular basis. I said kind of two tracks. So yeah. The alternate track, though, this is the one that's a little bit more in depth, and it's kind of a due diligence, if you will, and it may require you asking some questions. And the intensity, the probative nature of these questions, I think, is really going to depend on what it is. So let's say you're getting a product that has been delivered to you and the box says made in China, but your vendor is representing that it's made in Canada or made in Mexico. I think that's the kind of thing where you need to kind of pause and say to them, hang on here, I need to ask some real questions here. Like if they say it's made in Canada and the box says made in Canada, then I think you have no reason really to question that. But if you have questions where the vendor is unable to give you a clear answer, or where the vendor you're getting mixed messages in some respects, then I think it is incumbent on these resellers, these people who are selling directly to the government, to make sure that you're asking questions. And sometimes that might involve, asking for clarification. You present pictures, you interview folks. Maybe it actually goes back so far into the line there to figure out what does the manufacturing look like? Where are the various steps taking place? Where's the product substantially transformed? Companies, I think, are generally going to resist that, but as part of an audit, as part of a compliance type process, I hope that you have in your standard terms and conditions the flexibility that you can ask these questions. The worst case scenario is that they are delivering a product to you. They've represented that it's TAA compliant, that it's from one of these 120 plus approved designated countries. And then you have reason to doubt it, but you kind of bury your head in the sand. That's the kind of stuff that False Claims Act cases are made of. And that's the kind of thing that usually have some substantial liability associated with it. So I always encourage people, be thoughtful. And if you have questions, ask questions to kind of, resolve those concerns.